Welcome at our third and final panel, all about liability and risks. Now we have, of course, already heard during this day some people mentioning, what about liability? And that is something that we'll try to find an answer to at some point today, maybe, perhaps. Also, of course, risk management matters, compliance, how does that influence liability matters? What about cybersecurity? I think it was Tim that said earlier today that cybersecurity is also very important, and also from a liability perspective, because what if it goes wrong? Who is going to compensate my damage? To discuss all these matters with, we have three panelists. To your left, it's Professor Albert Verheij, Professor of Private Law at the Faculty of our university, Faculty of Law at our university. He's an expert in tort and personal injury. Also chief editor of the Dutch law journal Verkeersrecht, Traffic Law, which I'm a huge fan of. So you've read a lot about AI and mobility as well. That's besides a lot of other things, but he's going to kick us off on liability issues. Then after that, we have Jurriaan Parie, pronounce it correctly, right? From Algorithm Audit. Now I have to peek because I need to say that correctly. Algorithm Audit is a knowledge platform for AI bias testing and normative AI standards. And I read something about algo prudence. I'm very interested what that exactly means, so I'm looking forward to that. And then in the middle, we have Erik Rutkens. He is a cybersecurity expert that, to me, is most known from hacking a Furby of one of his children. But he does a lot more. That is at least as impressive. He is CEO of Hacksclusive. He's lecturer at Digital Society at the Noord, chairman of cybersecurity Noord that seeks to improve cyber resilience in small and medium enterprises, and has many more positions, so he's a perfect person to talk to us about cybersecurity and AI. First, I want to hand over to you, Albert. Go ahead.
Yeah, thank you very much, Nynke. Thank you very much for inviting me today. For me, this is also an opportunity to force myself to look into the combination of AI and liability, because AI is a very exciting development, and indeed, I understand that the non-lawyers, to put it like that, have a majority today. So I can imagine that some of you are a little bit concerned, what happens with liability? Are those damn lawyers going to kill off this exciting new technology, right? Because lawyers, I'm very well aware, are not always received with enthusiasm. I think somewhere in one of his plays, Shakespeare already said, or one of his characters, maybe Hamlet, let's first and foremost kill all the lawyers. And Martin Luther said that lawyers are bad Christians. So lawyers have a bad name, and maybe you are concerned for the lawyers. And, well, let's wait and see till the end of my talk whether there is a cause to be concerned. What am I going to discuss? Obviously some introductory remarks, and then I'm going to look at two instruments that have been proposed, the Product Liability Directive and the AI Liability Directive. And that is all very abstract, so I don't want to bore you with describing rules and stuff. I will look at the concrete case and try to draw some tentative conclusions in just 15 minutes. So, first of all, I think it's important to distinguish between two types of rules. First of all, safety rules that aim to make sure that the products that are being placed on the market are safe, right? So that is, you can say an ex-ante regime. It tries to prevent accidents and damage from occurring. And then the AI Act is an example. So I'm not going to focus on that. I will make some small remarks, but the focus is on liability rules. That's an ex post type of regulation. Something went wrong, people suffered losses, people were injured, and can they get compensation, yes or no? And of course, there can be some interaction. And because you can say, well, but if I comply with all the safety rules, can I then be held liable? Well, That's a very interesting question, and I'm going to answer that at the very end of my little talk. Well, first, what is important to note is what the proposed legislation does not do. If you look at certain activities that pose very high risks, such as nuclear power plants or oil spills, things like that, then you see that in the course of time, states, legislators, came up with a more or less comprehensive regime that consists of several components. You channel liability to one person so that it is certain who is liable and who has to take out insurance. Usually that person is liable even if he didn't make any mistake. Usually there's also a compulsory obligation to have an insurance, and there's a ceiling to liability. And sometimes, if there's more damage than what is covered by insurance, there is a fund that is, filled by stakeholders, by states, whatever. Well, that is a comprehensive liability regime that is in place in relation to oil spills, what I said, nuclear power plants that explode, things like that. But that has not been put in place in relation to AI. Although you can imagine that indeed there are some risks. And what can we infer from that? We can infer from that, I think, that at this stage, the European legislator is still searching, right? They have to await developments. They find it too early to completely regulate everything. They want to give room for innovations, if you want. So that already is a sign that, we don't have to be overly concerned, right? Now, having said that, I want to look at a very simple case. Let's assume there's a hospital and that uses an AI tool. Forgive me my simple words, but I try to keep it as simple as possible, for diagnostic purposes. And the AI to assist a doctor in making a certain diagnosis. The diagnosis proves to be wrong, and the patient gets injured. And then, of course, the question arises, can the patient get compensation? And if so, who can the patient approach for compensation? Who can the patient maybe sue in a court of law? There are two likely candidates. First of all, the hospital, and second, the manufacturer. Now, let's look at both possibilities subsequently. Now, first of all, the liability of the hospital. Yeah, indeed, you have the AI liability directive, but the AI liability directive does not put in place a specific liability regime for, liability caused by AI systems, tools, products, however you call it. And there are some rules on burden of proof, presumptions, disclosure duties to help the applicant, to help the claimant, the person who sustained physical injury, had to meet the burden of proof. But that's about it. So it's very limited. It's a very limited regime. So basically what you have to look for in a case like this, in this country, you simply have to look at the already existing rules regarding liability. So in that sense, the AI directive does not bring an awful lot of new stuff. One small remark, the AI liability directive applies to fault liability in non-contractual liability cases, so in cases where there's no contract. And of course, you can imagine, you can ask yourself, well, but does this directive apply, if it would come into force, does it apply here at all? Because obviously there is a contract between the patient and the hospital. Well, the answer, I think, is yes, because if you sustain physical injury, that amounts as well. You can say, well, that's a breach of contract, but at the same time, it is a tort. So that tort is a civil wrong, so that's another basis for liability. So even in cases such as this case, a contract between patient and hospital, I think that the rules proposed by the AI liability directive apply. But again, if we have to answer the question, is the hospital liable or not, in various situations that I'm going to analyze, we have to look at the already existing rules in the Dutch Civil Code. So the first question is the hospital automatically liable? Because they chose for a specific AI tool. Now, let's imagine that the AI tool is defective, right? And let's also imagine that was not discernible for the hospital. Nevertheless, the hospital chose this particular AI tool. And if, for example, you hire a carpenter and the carpenter makes use of a certain machine and there's something wrong with the machine, then point of departure is that the carpenter is simply liable for the machine that he uses. And does the same logic apply between hospitals and patients? And the answer is, I think, no, because the relevant provision in the Dutch Civil Code, I'm not going to bore you with articles, but the relevant provision in the Civil Code says, yes, as a point of departure, there is liability if you make use of a certain tool to perform your obligations under the contract, but there is an exception. And in other cases regarding medical liability, the Dutch Supreme Court has decided that the exception applies, because for the hospital, they have no control over, the machines that they use. If they would be held liable, then the cost of liability insurance might skyrocket. It might have huge impact on the healthcare sector. So the Supreme Court, to make a long story short, seems to create an exception for the healthcare sector. So that is not the case. I would say that the exception applies. So no, the hospital is not automatically liable for the defective AI tool. Let's look a little bit how the AI tool was used. And I like to distinguish between two situations. First of all, how was the AI tool integrated in the systems of the hospital? And the second question, the second situation I like to discuss is, how was it used? Well, let's look at the first. Imagine that it was negligently integrated by the staff. If it is clear that they made a fault, then the hospital is simply liable for faults of the staff. In that sense, AI is not different from, other things, right? Yes, then it is liable. But then it must be clear that indeed there was a fault on the part of one of the employees of the hospital. So AI is treated just as any other product. Now imagine, did the doctor make a mistake by accepting advice of the AI? Well, to be honest, I find that quite difficult, right? I mean, if AI comes up with some kind of risk analysis or something, if the doctor had no means to disagree with the advice given, then how can a doctor be at fault, right? So this case is very simple, so maybe we can discuss some more complicated cases, but that of course doesn't mean that the doctor should blindly follow any advice given by any AI tool. But of course, you must look if it was possible for the doctor to get extra information, etc., etc. So, I can imagine that if hospitals implement a certain procedure, that there is an advice by an AI tool, then the doctor, if he reads doubts, then he consults another doctor. So if there is some kind of process, then I do not think that very easily the doctor makes a mistake, and that means that not very easily the hospital is liable.
Do you have an eye on the time, Albert?
No, obviously not. So then, liability, okay, I can go very quickly if you want. I mean, so liability of the manufacturer of AI. Well, the proposed product liability directive treats AI systems, tools, products, however you call it, exactly the same as any other product. There is no increased liability or something. It is not so it is just business as usual. So the strict liability for the manufacturer, but that regime is limited to physical injuries, right? What is defective when it does not provide the safety which the public at large is entitled to expect? Well, that's pretty vague, but that's always the case. What is important to note is that, of course, AI is a moving target, right? There are self-learning systems, machines, etc., etc. So the fact that system causes injury, that later on that same system would not make that decision, that does not render the original decision. That doesn't mean that there's liability or something. It is a relatively flexible system. There's no reason for concern, I would expect. And then there's the state of the art, right? If the AI system is defective, but given the state of the art, given the scientific state of the art at the time of the production of the AI tool, given what is scientifically known, the defectiveness could not be discerned by the producer, by the manufacturer, then there is no liability. This is... yes, I end with the question with which I began. Can you be liable although you comply with the AI Act? The short answer is yes. The fact that you complied, in principle, yes. The fact that you complied with safety regulations does not mean that you can never be held liable. Why? Because sometimes safety regulations can get outdated by means of technological development, right? And it takes a long time to come up with new rules. So, as a manufacturer, you always have to, and that applies to anyone, you always have to use your own brain. If there is knowledge available that shows that certain products or certain applications can cause injury or death, then you cannot hide, obviously, behind it. You say, oh, well, but I complied with the regulations. Having said that, if I look at the AI Act, it is pretty vague, So, in that sense, I can also not really imagine a scenario in which you say, I complied, but So again, I don't think there should be deep concern with this. So, I come to an end of my little talk, and I hope that I convinced you, or maybe I put your minds at rest, that the lawyers are not, so far at least, are not going to put a stick in the wheel of this exciting new technology. Thank you very much.
Thank you very much, Albert. Now, Jurriaan, we already heard compliance. This is, of course, more along your field of work. So that and how did you call it?
Algoprudence.
Algoprudence, thank you. Yes.
Thanks, and thanks as well for the lecture on liability and safety. And we heard a lot of words about legal scholars, legal concepts, policy concepts, and like other more qualitative concepts. And I, as a statistician and mathematician, have been implementing AI myself, and data scientists are just wandering around with many questions. What decisions they have to make at the code level. And one of the things fascinated me when I was working on the transaction monitoring algorithm, validating that for the Netherlands for a large financial institution. There are just many questions and many decisions made without really good conceptual backup. And there's really an institutional impasse, one can say, to control these very important decisions about simple thresholds, about the money you can get out of a bank and then being flagged as like suspicious or not, that are not scrutinized by regulators. So from this kind of frustration about this institutional impasse, that their technology is not effectively regulated at the code level, I started working on an NGO, it's called Algorithm Audit, to think about standards for AI, and not only technical standards, but especially normative standards. Because not all decisions are technical, these are normative. Why is the one decision or threshold better than the other, and how can you conceptually support that decision? And this NGO works then on specifically bias testing, which is a very normative element, bias in the largest sense, not only in context of discrimination, but in general preferences for all different kind of micro-targeting, for instance, profiling. And this normative part for developing standards beyond the technical standards that, for our instance, now developed at the European level. And we do this by convening normative advice commissions. So the first step is to identify an issue, an open normative issue at the code level. The second step then is to collect all relevant information and put this just as a problem statement all together from an ethical, legal, and statistical perspective. Put this somewhere publicly available, identify different stakeholders, hear their opinions about the problem, whether it's like being resembled and formulated in the right context, with the right concerns, etc. And then as a next step, step 3, to convene a commission together, more a deliberative forum where people can come together about, for instance, questions, should we differentiate based on literacy rate or not as a municipality in Groningen or somewhere else in the Netherlands, to, for instance, profile recipients of social welfare to re-examine them for a certain control procedure, which is like a hot and happen thing in the Netherlands over the 10 years to apply these type of risk profiles on citizens. So we bring this deliberative forum together with a certain group of people in an open and kind of moderated manner with our experts involved. There are different stakeholders from a municipality, for instance, involved, as we did in Rotterdam with a specific case. And then we have this deliberative conversation about certain decisions that could be found consensus on, but that's not a necessary aim at all. So there could be a dissenting view. And we just publish this conversation online as an act of algo-prudence, which we can say, so together with the problem statement and the normative advice formulated by this diverse group of stakeholders, so we say that's kind of jurisprudence for algorithms at the code level. So, for instance, this list of eligible and ineligible criteria which can be considered for profiling in a certain public sector context. And algo-prudence can then be seen as jurisprudence for algorithms, but it's slightly different, especially when it gets more to the legal jargon. You have to think carefully how to put things into context. So it has certain characteristics, is that it's case-based. That's kind of a similarity. It's decentralized, and that really fits into the regulatory approach about self-assessment under the AI Act, for instance, that a lot of questions need to be resolved in a decentralized manner. So we're kind of moving away from an institutional top-down decision-making format, that all those fundamental rights impact assessments, they should be like conducted and performed at all different kind of organizations, at all different type of teams, with all different kind of, consisting of different actors, about fundamental rights issues, which is quite a big thing. So we say, fitting into this decentralized manner, we're going to provide these kind of normative standards for others to relate to reflect to. And at the same time, it makes concrete and flexible norms, because these issues can just vary case by case. And it's publicly available, which has a certain goal to question and debate the outcomes. And at the same time, it's non-binding. So whereas a centralized, institutionalized normative decision has certain legal mandate, that's not the case for this more bottom-up, voluntary, deliberative way of taking certain decisions. And this publishing this algo-prudence, the problem and the advice of the Commission then together online, it has certain effects. It is self-regulatory, that people have a good reason to deviate from it, and at least it gives a reference point why you can deviate from it. It is a kind of regulatory instrument that reflects state-of-the-art decisions, which is kind of fits into the the connection about liability law, but as well there are certain hooks under the GDPR to think about state of the art and how technology is moving fast and how to create norms and standards for it. And besides, it provides input for the positive legal sphere that courts and judges can learn from this voice out of society from a bottom-up perspective. And at the same time, it can inform politicians to question certain decisions at the code level. And with this way of working, we try to learn and harmonize this quite intense and complex interplay of legal, ethical, and statistical questions coming together in these type of questions, opening up a debate and questioning forum for society within democratic sites to discuss what type of technology we want. And at the same time, it promotes inclusion and participation for all those interested to engage with the algorithm published on the website and just start question and debating what decisions are made to create more bottom-up knowledge about responsible AI. So if you know any case, we're open for solicited and unsolicited advice. So supply through our website or apply through our website a new case at your organization or just something you are interested about. Hey, how should it work? And we can try to then pair up with that organization to look at the code level what decisions are made and how to create, hopefully, algo prudence out of it in democratic sites. Thanks.
Thank you so much. I'll make sure that I never forget the word algo prudence in my life after this. It was very interesting. Now we'll move on to Erik about a specific requirement from the AI Act, namely cybersecurity.
Well, Nynke, thank you. Nynke introduced me as a cybersecurity expert and a guy able to hack a Furby. Well, that's way too much credit. I'm at best, and for people who know will understand immediately, I am at best a script kiddie. And I am convinced that all of you are able to hack a Furby. And that's one of the biggest problems, because we have to ask ourselves the question, why is it so easy to hack a Furby? Or why is it so easy to hack into a website? That all has to do with software. And software is unfortunately insecure by default. And we are building all these AI systems on this software. So we need to make sure software is secure. A few questions, because I am the last guy standing between you and a drink.
There are two women standing between that as well.
Sorry. I understood there are a lot of legal people in here, but who of you does know how to program a little bit? You know, if then else? Who of you can explain to me the OC model? Aye. This is a fundamental problem of our digital society. We do not understand enough about software, about algorithms, about how cyberspace operates. Back to software again. Software is complex by nature. And it is also vulnerable, like I said before, by default. Let me give you a little example. I do not know if the lady from the RWD
Elise is over there.
Still present, but you rightfully said an electrical car, like a vehicle, is actually not a vehicle, it's a computer on wheels. Actually, Tesla is not a car company, it's a software company and an electricity company. And according to a company which I hold very high when it comes to security, a good software engineer only makes one mistake per 1,000 lines of code. Grasp this in your mind. And most of these mistakes are actually quite innocent. Since Microsoft, we're all used to glitching screens, blue screens, and okay, what's the remedy? What's the cure? How do we solve this? Reboot. This is actually, it's a sign of bad software. But these mistakes can also be used by criminals or other threat actors to misuse or exploit the software. And although I'm quite convinced that AI, for instance, can improve software quality, software as we know it right now will never be flawless. And actually the complexity of software goes beyond your imagination. Back to the Tesla again. A Tesla contains about 100 million lines of code. Just think of that. And then calculate how many mistakes potentially are in the code. And yet we get into this Tesla. I also do, and I encourage you all to do it, but we should be making and focusing on secure software. Because that is, like I said, the basis for all these AI systems. And although I think AI regulation is necessary, I think we're a bit too late. How can we actually think we can regulate a borderless, lawless, and also often anonymous world called cyberspace? How do we stop, for instance, Facebook's algorithms or TikTok's algorithms? I'm already getting crazy about it. I have a daughter and she's doing a side eye all the time. Or starts singing songs out of my childhood, which that is actually quite funny. And how do we understand the embedded software in a robot? Does anybody of you speak binary? And when I look at the proposed legislation, I think, what were you thinking, lawyers? Software without bias is a contradiction in termini. An algorithm is always a simplification of reality, and that is what we should teach our children. The composite nature and ever-changing nature of software, especially with AI, makes transparency very hard. I don't know if you heard of an initiative where people are trying to create a bill of materials, only then translate it to software, just to sort of understand it. But if you look at the software in a Tesla and these 100 million lines of code, maybe 30% of these lines of code were actually written by people from Tesla itself. It concerns software of all sorts of parties. And some of it we can read, some of it we can access, but if we're lucky, we can have a look at the binary code. And I saw nobody saying, I can read binary code. It's very difficult. So transparency is difficult. And let alone these governing bodies who need to oversee these algorithms and the systems underneath it, they do not have the capacity nor the knowledge to do so. And in terms of liability, luckily I'm not a legal expert, but if we look, for instance, at the software companies in the USA, I cannot think of one company that has been held liable for making bad software. Actually, they made a whole business model of it. Making bad software, letting us test it, fix it every Tuesday, and then when the software becomes unfixable, we say, okay, you have to buy a new version. I think, and I've written that a while back, that our society can go either two ways. And sometimes I compare it to the Wild West. Something really, really bad has to happen. More bad than Corona, more bad than the war between Russia and the Ukraine. And then actually the whole cyberspace, as we know it right now, will be destroyed. And then we will be able to rebuild it in an orderly fashion. Or we try to control it and become like, I think you told something about Hong Kong and China, control it like the Chinese do. Thank you.
Thank you so much, Erik. My first question is, why fix it on a Tuesday?
You have to maybe ask Bill Gates or one of his...
If you have his phone number for me, or... Good, let's open up the floor for questions. Michael, Mike is coming for you.
I had a question for Albert. While I haven't looked at any potential revisions of it, the AI product liability proposal hinges on the standards or the essential requirements in the AI Act to flip the burden of proof, right? Mm-hmm. But it doesn't hinge on the standardized version of them. It hinges on the essential requirements, right? So that regulation doesn't mention at all the harmonized standards that are present in the AI Act. Given that companies are get a presumption of conformity in the AI Act from applying a harmonized standard, but in the product liability regulation proposal, the standard they are held to is directly the standard in the AI Act. Mm-hmm. How is that able to be reconciled, particularly given that there seems to be a bit of a gap between these things, and that how far does an individual seeking to reverse the burden of proof need to have recourse to the standard itself that the company has applied, which is not an available document publicly? Mm-hmm, mm-hmm.
Yeah, of course. Yeah, it's difficult really to really predict how courts will deal with that. But my assumption so far would be that the court is also there are many presumptions that the court can use when it comes to the effectiveness, when it comes to the causal link between the AI to call it like that and damage. So basically, even if the standards are not very clear, that would be my short answer. If the claimant can build a case in which it seems likely indeed that the AI system that's caused the damage, then the judge is entitled to say, okay, I presume that's the product, the liability tool was defective. So indeed, I agree that there is a bit of a gap. And what often happens if legislators at the national, at the EU level do not know what to do, they just throw some powers at the judge, and they think, okay, you solve it in practice. So. And that of course carries the risk that different courts in different countries will use those presumptions in different ways, and that is a bit unlucky because the exact purpose of EU legislation is always to harmonize, to create a level playing field, etc., etc. And that is now not happening here. So in that sense, I agree, and that is a bit dissatisfactory and also difficult to. For everyone concerned, that's a bit unlucky. For lawyers that have to advise clients on how courts will deal with that. So yes, there is uncertainty. Yes.
Hi.
It's working.
Sorry, I have two questions. One for each of the presenter on my right. For Erik. More like a pragmatic question, forgive me. So, you work in cybersecurity, right? And I can understand that on the outset, one can imagine that in order to work in cybersecurity, you have to be a programmer, you have to know software engineering. But since cybersecurity is so intertwined with law, you don't know much about law, I don't know much about programming. What would you advise people, either a researcher now or a law student like myself, who want to work in the private sector? So we're not doing research, but I want to work, for example, in cybersecurity, which is one of our courses as well. How do we bridge that gap? Do you think it's essential for anyone who is studying technology law to also learn some basic programming, or for software engineering to learn something about law? Like, how do we bridge that gap? Because we are not speaking the same language. And as a CEO of a company, what would you advise a student like us, researcher like the rest of us? If you want to work in cybersecurity, what am I looking for? Is it a law degree or is it just training on the go because it develops so fast? Sorry, it's a long question. The second question is shorter. You mentioned something like a financial institution, for example, say like ING. If any of us want to get a mortgage, right, we are afraid that nowadays a lot of financial institutions are using AI to screen out and give you a credit score, right? How do we, at least in Europe or in the Netherlands, as far as you know, how do we prevent or how do we mitigate that bias? Because if they're using AI, which means they're using present training data, right? So there is a innate bias in the training data that, sorry to say, as a minority, I would say the majority of home buyers in the past are white, native Dutch national, right? So that's the set of training data they have in the bank. It's already biased. So how do you mitigate that bias if I want to, or another person who is in the minority group, want to get a higher or fair credit score in order to get a mortgage? It's a very practical thing.
Thank you so much. First, Jurriaan,
Sure.
the mortgage. How are we going to manage it?
So as well, it relates to the point made in the previous discussion that we have been shifting biases over the last centuries and decades in society, in the analog world, as you can call it. Now in the digital world, we have to implement the safe kind of transparency and checks and balances mechanisms to think about these problems in the way as we used to in the past. These are not new questions. Like we've been thinking about like justice and fairness for ages and centuries, and we have built institutions. Now we just have to make these mechanisms, that these type of questions come into democratic side such that they can be resolved and discussed and debated upon how to deal with them. And that's not happening now, that's not happening in finance, that's not happening in insurances, that's not happening at big tech firms. So that's basically our kind of mission to demystify AI and open up the normative black box just to discuss this within democratic side, yeah. And how then it should be debiased, that's like beyond our reach as well as an NGO, but we at least want to bring it kind of to the people.
Thank you so much. Erik, education. What do lawyers need to know about cybersecurity? Do we need to program?
should be a very
I'm
it
taking
should be an added
notes,
value.
so.
But you actually asked a number of things. First, I don't think that everybody who wants to do something in cybersecurity needs to be able to program. Actually, it's a very wide area of where we need all sorts of expertises, from legal to technical to organizational, etc. And then relate that to education. One good step would be that different studies, like technical studies, but also legal studies, do more projects together to tackle problems instead of working in these pillars and then ask somebody to do a single course, saying, okay, now you know something about cyber security. More on the long term, I need the whole education system should be reformed, but I try to lobby for that, but I don't know if I will see that.
Thank you so much. More questions?
I had a question. Yeah, I was sort of triggered by this example given that who of us here speaks binary, and I understand the questions and the direction which I understand heading towards. So if you are thinking about, for instance, which type of education should your children get to have a good job, or which type of skills we should develop as a society to make a meaningful contribution to the trends which are out there and so on, so that we need to develop those skill sets. But then again, when thinking about society in general, or taking the terrible me as a consumer perspective, like why do I have any type of obligation to speak binary? Why is the system or whatever it is not capable of talking to me, as it were, in a language which I understand? And I think this is something which is something which we did not touch too much upon today, but which I think is very central to this whole discussion, that why do we have this tendency to make this exceptionalist approach when it comes to artificial intelligence? What's wrong with it just dealing the same way than we made product liability for the last 30 or 40 years, right? And I'm not saying that it's a different discussion than saying what is the best approach. So should we have like a competition type of approach? That's a different discussion. But why are we always looking for this type of exceptionalism as soon as somebody talks about AI? And I'm a bit afraid that we're all sort of like becoming stochastic parrots of, the big tech companies, because they've been molding our minds so much that, this is special, this is the future, whatever. So I don't know what your take about this is, but in that sense, I think when it comes to regulation, it's actually a good thing that it is there, because it sort of changes something in the dynamic, which is there. It's certainly not perfect, but at least it has the potential to change a bit the dynamic of that discussion. I don't know what you think about it.
Would you like to respond, Erik, Jurriaan, Albert?
Yeah, I can. Well, I mean, when it comes to a liability perspective, AI products are just like any other product. So there's no exceptionalist approach, and I think that's good. When it comes to, I mean, I kind of can relate to what you say. I mean, the technology is changing. So whatever skills or whatever knowledge we teach our children in primary school, by the time they enter the job market, maybe everything is different, right? When I was in school, they also learned me something about computers, and that was complete obsolete by the time I entered the job market. I also think it's a little bit too easy to say we should change exactly. So I respectfully disagree. We should change the entire educational system. Come on, I mean, you learn a certain job, then you start working in a certain area. And if it's important to you that you understand more about the environment and biology, well, then as a lawyer, you, in the course of your job, and maybe you follow some courses, read some books, talk to experts, and then you increase your knowledge. I mean, lawyers who are specialized in medical liability, they know an awful lot about the human body and what can go wrong and certain operations, and they get training on the job. So you cannot do everything as a law school because where do you start? No idea. So of course you should keep an open mind, and of course people should not be these hyper specialists who know nothing about the world outside law, but I think it's illusionary to integrate all necessary knowledge in a legal education or in any other education whatsoever. So we should not be too concerned. Yeah, nevertheless, but I can talk forever, but no, it's fine, it's fine. It's just,
okay. We'll continue during the drinks, of course, but Jurriaan, you would like to respond.
I'm not advocating for like a big tech or AI exceptionalism, but I think at a kind of deeper level, we are changing or seeing a change in reasoning paradigm shift, where we used to think about the world in terms of predominantly words. Now, numbers are getting more and more to the fore. So we are talking about higher dimensional, p-dimensional correlations for p to infinity, like for very large numbers. This is like beyond the conceptual imagination of the human mind, but we are basing decisions in our real world on these type of reasoning paradigms. So then I think we do need more kind of a new or enriched jargon based on this like legal legacy we have, enriched with new concepts. So non-discrimination law in the European context is not like the best conceptual fit for these higher dimensional differentiation type of questions. So I think there should be more legal tech innovation from that perspective to grasp the challenges which are ahead, for instance, from a non-discrimination perspective.
Thank you so much. Would you like to add something, or because I saw you?
Well, just a little bit from a security perspective, and I'm always a bit ambivalent because the state of software security now is very bad, and it's a sort of business model of manufacturers. So actually, in the current situation, when I have, for instance, a consumer product at home, I should worry about the security of whatever device or software I'm using. But that is not normal. Actually, like Oscar is saying, we should just be able to use and enjoy it, not worry about security features or is this device up to date or whatever.
Thank you so much. We have a question in the middle. I saw your hand raised. Right?
Yeah, thank you. I have a question for Albert because maybe it's a terminology thing, but when you talk about defective, I'm an engineer, computer scientist, so then something is broken when it's defective. The problem with those AI models that we have in healthcare now is they make a prediction. Mm-hmm. So there is a certain accuracy of the model. So if a vendor would say, I've got a model that's 80% accurate, and that's something that is sold to a doctor, and the doctor accepts the wrong answer, which is part of that 20% that is not accurate, because it's 80% accurate. How does that work then? Because it's not the software is not broken. It's doing a prediction. It's doing its job. It's doing what it's supposed to do, but it has a certain accuracy. It's not binary. It's a percentage that it.
Sure. But I mean, let's say, would we accept that the software in planes is such that 20% of the planes they crash? Is that acceptable?
No, that's why we have human oversight. The thing is that most of this, when we build models, what we get in healthcare often is that they say it has to be 100% accurate. That's never going to happen. Those deep learning models are...
Oh, sure. I mean, 100% accuracy doesn't exist, right? But that indeed, therefore exactly because of this reason, so I'm maybe giving the question back to you, therefore the legislator came up with this criterion, what is the public entitled to expect in terms of safety? And I'm pretty sure that cars that crash 20% of the time, planes that crash 20% of the time, 20% of the patients, receive the wrong diagnosis because of the AI. To that, I feel pretty certain to say that courts will not find this the level of safety that patients are entitled to expect. So that's one part of the answer. The other part is, of course, you have to compare it, I think, with the level of safety that would exist without AI. And so that is always, and I was told by Nynke that we should not talk about autonomous vehicles, but nevertheless, I think it's just a good illustration. I mean, you can say that autonomous vehicles, they make way less mistakes than human drivers, so they are safer. And at the same time, they sometimes make mistakes that the human driver would never make. And how do you deal with that? And my personal take on that would be that if you can prove that AI systems make way less mistakes and cause way less injury and losses than humans would do, then already it is a big step forward. And then, of course, then I would say that the public is pretty happy. So by and large, and then the question is this particular AI system, it's way better than human decision making, but how is it compared to other AI systems? So what is kind of the standard? And
benchmark.
So that is a way that the lawyer would deal with that. So there are no hard and fast answers, but I totally accept and understand 100% safety does not exist, but that's not what the law requires. No.
Thank you so much. I'm sorry that we have to keep it at these questions. I'm sure that you have tons more that we can discuss during the drinks. But for now, whilst you thank the speakers for the great input, I would like to hand over to our students. Thank you so much.